Good afternoon, everyone, and thanks for joining us today for our Workers' Compensation 101 webinar. I'm Ben Gonzalez with TDI's Communications Office, and over the next hour, you're going to get an overview of the workers' compensation system, learn about your rights and responsibilities, and then we'll have some time for questions at the end. Our presenter today is Kelly Varudis. Kelly's the manager for claims and customer services at the Division of Workers' Compensation, and she also oversees our virtual call center. So let's get started with Kelly's presentation. Then I'll see you back here for our live Q&A shortly.
Hi, I'm Kelly Varudis with the Texas Department of Insurance, Division of Workers' Compensation, and I'd like to welcome you to Workers' Compensation 101. So what is workers' compensation? The textbook answer: workers' compensation is a state-regulated insurance program for employees injured at work, which pays for medical bills, some lost wages, and isn't mandatory. But what does that mean? The real-world answer is Texas doesn't require most private employers to have workers' compensation. But private employers who contract with government entities must provide workers' compensation coverage for the employees working on the project. Some contractors may require their subcontractors and independent contractors to have workers' compensation. When an employer provides workers' compensation, we call them subscribers. The grand bargain premise underlying all workers' compensation systems is that covered employees should receive presumptively fair, no-fault, and universal, though limited in amount, benefits at no cost. In exchange, employers are broadly shielded from tort liability for work-related injuries and deaths. Employees give up their right to sue, and employers give up their right to refuse compensation for their employees injured on the job. Unlike other lines of insurance, workers' compensation is the only line of insurance where the policyholder who is paying the premiums, in this case the employer, is not the party filing claims on the policy and is not the recipient of any claim payments resulting from the policy. In the Texas workers' compensation system, injured employees have certain rights and responsibilities. Let's first talk about their rights. Employees have the right to retain their common law right to sue their employer. When they're hired, employees are provided with a new employee notice, which explains their rights and responsibilities. The employee has 5 days from their date of hire or from being informed in writing that there's workers' compensation coverage to reject it. Employees who reject coverage must do so in writing and can't obtain income or medical benefits related to the injury. Employees have the right to receive income benefits if they are due. They also have the right to receive medical care for their work-related injury as long as it's reasonable and necessary and related to the work-related injury. Employees have the right to get help from the Office of Injured Employee Counsel, a state agency that offers free help to injured employees and their beneficiaries that don't have an attorney with the workers' compensation claim. Employees have the right to dispute resolution, which is the ability to present their case when there's a disagreement. They have the right to hire an attorney to represent them for their case. They have the right to have their claim information kept confidential. And they also have the right to choose who their treating doctor is. Now, if they're in a workers' compensation network, they must choose a doctor from the network's treating doctor list. Along with rights, injured employees also have certain responsibilities. Injured employees must tell their employer within 30 days if they've had a work-related injury or they've been diagnosed with an occupational illness. They must follow their network rules if they're in a certified healthcare network. If they're unsure if they're in a network, employees should ask their employer for network information. They must explain to their treating doctor how the injury happened and if it was work-related. Fill out the employee's claim for compensation for a work-related injury or occupational illness, or DWC Form 041. They have 1 year from their date of injury to file the form with us. They must let us know and the insurance carrier know how to get a hold of them, as well as let us and the insurance carrier know whenever there are any changes in their pay or work status. Employers also have certain rights and responsibilities. Employers have the right to contest the compensability of a claim, meaning if they don't agree with the insurance carrier's acceptance of it, they can request a hearing to dispute it. Employers have the right to be notified of any dispute resolution proceedings. Employers also have the right to attend any dispute resolution proceedings and even present evidence when it's appropriate. Employers should always report fraud to us at the Division of Workers' Compensation. I've included a link to our fraud page, which details what we investigate and how to report suspected fraud later in this presentation. Employers can contact us to let us know if their insurance carrier isn't providing accident prevention services. Licensed insurance carriers are required to maintain or provide services, including surveys, consultations, training, and recommendations. They also need to provide analysis of accident causes, industrial hygiene, and industrial health services. Employers can receive return to work coordination services from their insurance carrier and from DWC. Services from the Division of Workers' Compensation include return to work consultation workshops, training by the Division of Workers' Compensation, a return to work employer guide, which can be downloaded from our website, and return to work reimbursement programs. Employers must tell their employees that they carry workers' compensation insurance by providing a written notice of coverage to new employees upon hire. The written notice must inform employees of their right to reject workers' compensation coverage and retain their common law right of action. This notice must be in the wording and format prescribed by the Division of Workers' Compensation. Employers must also post a written notice at their place of business telling their employees that they carry workers' compensation insurance. This notice must be in the wording and format prescribed by the Division of Workers' Compensation in English, Spanish, and any other language that is common to the employees, and must be posted at an easily visible location of the employer's place of business. Things like a break room or a hallway that all employees must walk through would be a potential easily visible location. Not only does posting these forms comply with the law, it's a good idea to let employees know who their workers' compensation carrier is. There's less confusion when employees already know what to do and who to contact. Let's take a look at some of these notices. First is Notice 5. This notice is how employers inform employees they don't provide workers' compensation coverage in Texas, which we call non-subscribers. While non-subscribers don't provide workers' compensation insurance, they may provide other benefits to injured employees. Next is Notice 6. This is how employers notify employees they have workers' compensation coverage through a commercial insurance provider. It lets employees know what insurance carrier provides the coverage and the effective dates of the policy on the notice. Notice 7 notifies them that the employer is self-insured. In Texas, private employers can apply for a certificate of authority to self-insure with the self-insurance regulation section of the Division of Workers' Compensation. If approved, employers are allowed to pay their own workers' compensation losses rather than buying an insurance policy. Notice 10 notifies them of coverage through a group of self-insured employers. Texas workers' compensation self-insurance groups must be made up of at least 5 employers within a same or similar industry, sponsored by a Texas trade association, and are certified by Texas Department of Insurance's Company Licensing and Registration Office. Employers must report injuries to their insurance carrier when one of 3 conditions exist. 1, the injury results in the employee losing time from work for more than 1 day. 2, the employee has been diagnosed with an occupational illness. Or number 3, the employee has suffered a work-related fatality. If any one of these conditions exists, then the employer is required to file the employer's first report of injury, or DWC Form 001, with their insurance carrier within 8 days of being notified. Employers must keep record of these reports for 5 years, or according to OSHA standards, whichever is longer. They also must provide a copy to their employee along with a copy of the employee's rights and responsibilities. It is important to note that partial days can be added to meet 1 full day of the reporting requirement. Even employers that are non-subscribers must report injuries and fatalities if they have 5 or more employees. Non-subscribers report those to us using the employer's report of non-covered employees' occupational injury or disease, also known as DWC Form 007. Another form that employers are responsible for is the Employer's Wage Statement, or DWC Form 003. Employers must fill out the form and send it to their insurance carrier and injured employee within 30 days of being notified the employee is either entitled to benefits or a fatality is work-related. The employer must report 13 weeks worth of wages. But what if there aren't 13 weeks worth of wages? They're a new employee. It happens. For these situations, the employer needs to consider if they need to report wage information for someone who has the same job or similar duties to the employee to complete this form, as long as they provide the full 13 weeks worth of wages. This is an incredibly important form because it's what the carrier uses to determine the average weekly wages, which is the average amount of money paid to the injured employee for 13 weeks before the injury or illness. The average weekly wage is then used to calculate how much to pay the injured employee for any income benefits they may be entitled to receive. Now, the 30-day time frame is for mere submission to the carrier. When we at the Division of Workers' Compensation request a wage statement, the employer has 7 days to file it. Employers also must report any changes to the employee's wages or employment status using the Supplemental Report of Injury, or DWC Form 006. Wage changes could mean an employee has gone from full-time to part-time. Employment status changes could mean reporting when an employee is resigned or has been terminated. And employers must report when an employee returns to work, as well as when an employee loses time after having returned to work. Essentially, this form is used by employers to tell the carrier when wage and employment status changes have been made. This form is extremely important for the employer because it allows the carrier to adjust the claim more accurately. Adjusters want to make sure they correctly adjust benefits so that it doesn't affect employers' premiums. Employers should submit this form within 3 days when the employee loses time from work due to the injury, or when the employee was initially at work, then began lost time. Essentially, report when there are any changes to your employee's ability to work. When there are wage or employment status changes, the report is due within 10 days of the change. Employers are also responsible for providing a safe workplace. That means they must take every action necessary to make sure employees are safe when they are at work. We at the Division of Workers' Compensation provide a variety of resources to help keep employees safe. They can always contact OSHCON, or Occupational Safety and Health Consultation Program. Consultants are located across the state and provide free, confidential help with safety regulations, and can also assist in identifying hazards. Employers can also attend a variety of publicly and privately offered training events, including regional safety seminars, OSHA 10-hour construction courses, Texas Workers' Compensation conferences, and custom on-site training. They can access safety training resources, such as free online publications, helpful links, and DVD loans. And they can contact their insurance carrier to request accident prevention services. Let's move on to the types of benefits provided through workers' compensation coverage. I'd like to start off with income benefits, but it's important to first discuss what disability means in relation to workers' compensation. Disability is when a work-related injury or illness causes an injured employee to lose the ability to earn their weekly wages. Disability refers to an inability to earn an income, not to a physical handicap. Sometimes an injured employee may have what is called partial disability. This is when they can work, but limited in some way, which prevents them from earning their full pre-injury wages. In order to receive most income benefits, the injured employee must have disability. There are 4 types of workers' compensation income benefits that replace some of the money an injured employee has lost because of a work-related injury or illness, except for impairment income benefits. The first income benefit an injured employee may receive is temporary income benefits. An injured employee may be able to get temporary income benefits if a work-related injury or illness causes them to lose some or all of their wages for more than 7 days. Those 7 days can be consecutive or accrued. It's possible an injured employee could miss 2 days one week, 3 days another week, and maybe a month later, their doctor takes them off work. Those days can be combined over time. Temporary income benefits are paid by the insurance carrier on a weekly basis and should equal 70% of the injured employee's average weekly wage. However, if the injured employee earns less than $10 per hour, they should be paid at 75% for the first 26 weeks. Then they can be adjusted to 70%. In order to pay benefits for the first week, the injury has to cause a loss of some or all of pay for 14 days or more. Remember disability? Temporary income benefits will end when the injured employee is able to earn their average weekly wage again, or once they reach maximum medical improvement. There are two potential scenarios for reaching maximum medical improvement: medical, or when a healthcare provider determines that no further healing or recovery from the injury can be expected, and statutory, 104 weeks after the 8th day of work-related disability is reached. Next is impairment income benefits. These are payments an injured employee may be able to get if they have a work-related injury or illness that affects their body as a whole. The amount of benefits an injured employee can get is based on an impairment rating that is assigned by a healthcare provider. They can be working and earning average weekly wages. These benefits are owed regardless of disability since they're based on the impairment rating. Benefits are normally paid weekly and equal 70% of the injured employee's average weekly wages. Impairment income benefits begin once an injured employee has reached either medical or statutory maximum medical improvement, and end once 3 weeks are paid for each percentage of impairment. So let's say the impairment rating is 3%. That means impairment income benefits would end after 9 weeks had been paid. Supplemental income benefits are income benefits that the insurance carrier pays to an injured employee after their impairment income benefits end. Unlike with other income benefits, an injured employee must apply for supplemental income benefits on a quarterly basis. They have to have an impairment rating of 15% or more and complete certain work search requirements. If an injured employee received a lump sum payment or can earn 80% of their average weekly wage, they're not eligible to receive supplemental income benefits. The amount of supplemental income benefits is what you get when you subtract the difference between 80% of the average weekly wage and any wages earned after the work-related injury. The insurance carrier pays benefits on a monthly basis. An injured employee may be able to get lifetime income benefits for certain severe injuries. These benefits are paid for the life of the injured employee. Benefit payments equal 75% of the injured employee's average weekly wage, with a 3% cost of living increase each year. If an injured employee believes they may be eligible for lifetime income benefits, they can send a written request to the insurance carrier. Death benefit payments help families replace some of the money lost when an employee dies from a work-related injury or illness. These benefits are paid to legal beneficiaries, like a surviving spouse, minor children, children less than 25 years old who are enrolled in an accredited college or university, dependent grandchildren, or other dependent family members. Non-dependent parents may receive death benefits if there are no surviving eligible dependent family members. To receive death benefits, a beneficiary must submit a beneficiary claim for death benefits form, or DWC Form 042, and include supporting documents like a copy of the death certificate, a marriage license, or birth certificates. Death benefits are 75% of the deceased employee's average weekly wage. The amount of benefits is distributed amongst the beneficiaries, and there are different durations based on the type of beneficiary and if the injured employee was a first responder. Benefits may also be available for burial expenses. Someone who pays expenses for the burial of an employee may be able to get burial benefits if the employee died because of a work-related injury. The person who has the expense must contact the insurance carrier in writing within 12 months of the date of death and attach copies of all related bills. The other type of benefits within the workers' compensation system besides income benefits is medical benefits. The insurance carrier pays for all medical benefits as long as they are related to the compensable injury and are deemed reasonable and necessary. The injured employee does not pay any copays or have any deductibles or coinsurance. Insurance carriers pay medical bills for non-network claims according to our medical fee schedule. For certified healthcare network claims, they pay according to the network's contract. Healthcare providers cannot bill an injured employee for care that is related to the injury. And insurance carriers must also pay medical bills according to the division's medical fee guidelines, which dictates the exact payment amount for individual services. There is a dispute resolution process for when there is a disagreement between parties in a workers' compensation claim. Let's discuss what steps are involved in the dispute resolution process. The first is the benefit review conference. This is an informal meeting with the parties and a Division of Workers' Compensation benefit review officer to talk about claim disputes. The benefit review officer will help the parties to list the disputes, discuss information and facts about the claim, get more information if needed, and work to reach an agreement. If the parties don't reach an agreement, they may go to a more formal meeting called a contested case hearing. During a contested case hearing, parties offer evidence about disputed issues before a Division of Workers' Compensation administrative law judge. Witnesses answer questions under oath, and the administrative law judge listens as each party explains its side of the case. After the hearing, the administrative law judge will review the evidence and make a decision on each issue. If either party disagrees with any part of the administrative law judge's decision, they can ask the Division of Workers' Compensation appeals panel to review it. Now, the appeals panel is a group of 3 administrative law judges who review a written appeal of the contested case hearing decision. The appeals panel does not hold a new hearing. Instead, they review all the evidence presented at the hearing. After this review, the appeals panel may agree with the administrative law judge's decision, reach a new decision, send the decision back to the administrative law judge for more action, or a combination of the 3. If a party is still not in agreement with the appeals panel's decision, they may ask for judicial review. The appeals panel is the last step in the Division of Workers' Compensation dispute resolution process. But if either party disagrees with any part of the appeals panel's decision, they may ask for judicial review by filing an appeal in district court. Now, I know that we've covered a lot of information in this presentation. So here, you will find a list of resources that we've covered today. At the Division of Workers' Compensation, we have a lot of resources and additional information available on our website. We also break things down for each system participant, like injured employees, employers, insurance carriers, and healthcare providers. If you ever have a question, especially if it's specific to a claim, please feel free to give us a call. On this page, you'll find a link to our fraud page, which is where you can report fraud, but also find additional information related to the fraud investigation process. There's also a link to the return to work services that we here at the Division of Workers' Compensation offer. There's a link to all of our forms that we've discussed, including the rest of the forms that we have within the workers' compensation system, including the notices, and a link to additional information about income benefits. I've also provided 2 phone numbers. The first is for customer service, where you can talk to any of our agents across the state regarding any workers' compensation questions that you might have. Second, I have a phone number listed for workplace safety. I've also included a link to the workplace safety website.
All right, welcome back to our Q&A portion of the webinar. I think Kelly was right. That was a lot of information, maybe a little more than 101. Kelly, if you'll please turn on your camera, we'll get started. Joining us now to field your questions is our presenter, Kelly Varudis. Again, Kelly's the Program Services Manager for Claims and Customer Services at DWC. Just a couple of ground rules that we need to pass along before we get started with the questions. Anything about a specific company we're not going to answer in this forum, you can always email us those questions. Use the email dwcinsuredqa@tdi.texas.gov, and you'll find that email in the chat. And of course, we need to maintain the confidentiality of all workers' compensation claims. So Kelly can only answer general questions here today. If you have a question about a specific claim, you're going to need to contact DWC Customer Service at that phone number she mentioned, 800-252-7031. And that's also going to be in the chat. So please use the Q&A feature at the bottom of your Zoom window to enter your questions, and we'll get started there. Anything that we don't get to today during this session, you can always email us at that same address, dwcinsuredqa@tdi.texas.gov, and we'll work on getting you an answer. All right, Kelly, you ready to take some questions?
I am ready.
Awesome. All right, first up, you mentioned optional. Why would someone reject workers' compensation benefits?
Sure. So one of the things that we tend to say quite frequently when we're talking about workers' compensation is it depends, right? There's a lot of nuances associated to workers' compensation, and it would really be up to that individual's preferences and wants. It could potentially be that they want to maintain that common law right to sue. It could be that they have some kind of liability insurance that they personally have that they would like to maintain coverage through instead of opting to be part of a workers' compensation policy. So those are just some basic reasons why somebody might decline workers' compensation coverage, but it would really be up to that individual and their wants.
Okay, sounds good. Next up, this one's a little more specific. It says, what if DWC 003 form is incorrect based on what the clients are making compared to what the employer is reporting? How do you make that justification?
Sure. So this is another one where I'm going to say it sort of depends, right? So if the issue is that maybe the injured employee is earning more than what's being reported by the employer, it's possible that maybe that injured employee has another job that they're getting additional income from. If that's the case, there's a completely separate form that injured employee would need to fill out and submit. That's the DWC form 003ME for multiple employment wage statements. If it's just a discrepancy with, maybe the employer didn't quite calculate those wages correctly and provide that on the form, use the insurance carrier can reach out to that employer and let them know that they need to submit an amended wage statement form and make a correction. Now, if it's that the injured employee specifically doesn't agree with what that employer has stated and how that wage is being calculated, that's something that they can go through the dispute resolution process on.
Okay, sounds good. Let's move on. If the injured worker is required to report the injury in 30 days from when, you would think the accident, if that's an obvious answer, but what about something where you don't know exactly when the injury occurred?
Sure. So when we say 30 days, it's 30 days from when the incident occurred or when that injured employee knew that their injury or their illness was work related. Sometimes that can mean that a healthcare provider is the one who confirms that that incident resulted in the current condition. But it's 30 days from when they knew or should have known that the injury or illness is work related.
Is that something that can come into play when there's like repetitive motions or injuries?
Certainly, yeah.
Okay. All right. Next up, will insurance pay for an office visit? I guess this is from a provider. If the patient was already seen at an emergency room, can they make an insurance claim for an office visit on the same day?
Sure. So when it comes to payment of medical treatment, payment would be for reasonable and necessary treatment. So as long as that treatment is reasonable and necessary for the accepted workers' compensation claim, then the carrier should pay for that treatment. Now, I will say if you're experiencing an issue with getting payment on any kind of medical treatment, please reach out to our Comp Connection department that is specifically dedicated for answering healthcare provider related questions. And they can be reached at 1-800-252-7031, same phone number, just option 3 for our Comp Connection.
Very good. Another specific case here to talk about. What if there's a third insurance company involved, that there might be a liability claim going on? How do you process the work-related part of that if there's also a liability claim?
That's another one where I'm going to say it depends. So I would highly recommend contacting us at the division to discuss the specifics of that. Unfortunately, I'm not going to say there's an easy way to process that because there's a lot of nuances at play. And if you have questions about how to go about that, I would highly recommend that you give us a call and we can help you navigate that.
Perfect. Okay. Another provider, this one says, we're a physician's clinic and we're treating doctors. We're not designated doctors, but if an employer doesn't agree with what the physician on the work status report has and contacts our office, the physician's office, what's the course of action to try to resolve that dispute?
Sure. So if a employer is not in agreement with a work status report, I would say that employer needs to follow up with their insurance carrier that's processing that claim on their behalf and discuss that with them. It might be that, there's some modified work duties that need to take place in order to get that person back to work. It's also possible that the insurance carrier could then pursue dispute resolution regarding that work status report.
Okay, but there's always pathways for these specific issues that come up, and that's usually contacting us.
Correct.
Okay, next question. Is there some kind of online tool for fee lookups where providers can either view the exact dollar amount that the Texas Workers' Comp fee schedule has for each CPT code, or is there a range that we can see?
Sure. So the workers' compensation system utilizes the Medicare framework for a lot of our fee guidelines. Now, there are some procedures and there are some treatments that we do have different fee guidelines for. So that's another one that I would recommend. If you have some questions, I'd really recommend that you contact our Comp Connection side of the house, and they should be able to help you identify what specific fee would be applicable for that treatment.
Okay, sounds good. We had some questions from medical providers, and this one seems to be from the injured worker side, kind of a two-parter. What is considered delay of treatment? Like if you can't get an approval for an MRI, and what rights do patients have for treatment?
Sure. So this is another one of those nuanced questions. Now, it depends on whether or not the treatment that's being requested is going through pre-authorization or not. So that's something that, again, the timeframes on that are going to really depend on the nuances. And so I would highly recommend giving us a call if you feel like things aren't going in the kind of time frame that you think that they should, if it seems like things are delayed. And we can look into that specific situation and let you know what the appropriate time frame should be. And if that's not being adhered to, then we can contact the insurance carrier and try and help get things back on track.
Okay, and that's the same customer service number?
Yes, sir.
Next question here. What is the specific waiting period for referrals to a specialist?
So waiting period for referral. I don't know that there's really a waiting period per se. This is one of those where, if a referral is needed, I would contact the insurance carrier on that to discuss that. And again, if you feel like you're not getting the response that's needed, then I would, follow up with us at our customer service number.
Okay, sounds good. I'm an insurance agent. Can I raffle off a gift card to my business owners and clients every month to promote safety in the various locations? Is that okay?
I don't know that we necessarily have jurisdiction over that, but I would maybe contact our workplace safety, and they can probably provide you some guidance in regards to whether or not that would be all right.
Yeah. Here's a new question. I handle workers' comp in my organization. Sometimes associates go treat with their personal doctors, then after a few days report that they got hurt during work. How is this situation treated, and is this supposed to be accepted as a workers' comp claim?
So this is one of those situations where it kind of depends. So if the claim is under a healthcare network, then it's possible that those visits may not be payable from the insurance carrier. However, if the claim is not under a healthcare network, the injured employee would need to let that doctor know that the injury was related to work. And it's possible that healthcare provider would be willing to accept workers' compensation insurance, and would just have to work with submitting the correct bills to the insurance carrier.
Okay, so that's another one of those cases where there's specifics and factors to be identified, and so it's probably best to contact us directly, and we can find out and get you a more specific answer.
Right.
The next question up here is, do employees of political subdivisions have the option to waive workers' compensation coverage?
That is a good question that I would need to look into. There are some
research.
different rules that apply to political subdivisions. I also believe that they're required to provide workers' compensation insurance. So that's one that I would like to look into and get back with you on.
Okay, so they can email us that question and we'll get back to them on that one. I'm not familiar with this acronym, but when does SIBS kick in?
Yeah, so we are at the Division of Workers' Compensation love our jargon and our acronyms, and that's one that applies to our supplemental income benefits, or for shorthand SIBS. So when it comes to SIBs, supplemental income benefits, those begin once impairment income benefits end. So basically what happens is those impairment income benefits are paid out to the injured employee based on the impairment rating that has been assessed. So in order to be entitled to supplemental income benefits, that injured employee has to have a 15% impairment rating or higher. So this is going to get a little mathy, so I apologize. But the impairment income benefits get paid 3 weeks worth of percentage of impairment that is assigned, right? So based on that is how long the impairment income benefits will end and potentially when supplemental income benefits will begin. So again, it's one of those, it's nuanced, it depends, but supplemental income benefits should begin the day after impairment income benefits. And when there's a 15% impairment rating or higher, there's also a couple of other nuances with that, that go along with it, like the injured employee has to apply for those benefits. They have to, not be earning the pre-injury wages that they had. If they're unable to work, they have to be completing work search requirements or enrolled in a vocational rehabilitative service. So that's a really good question. If you have any other kind of like nuanced questions that go into that, I'd highly recommend giving us a call, because that's one of those sticky ones, and it's got a lot of nuances to it.
Boy, that was such a short question. When does SIBS kick in?
I know.
Crazy answer. Oh, that was good. Here's the next question. We're new to the workers' compensation. Are there classes that we can take regarding what submissions and what filings we need to make to your state?
Sure. So unfortunately, at this time, we don't have regular classes or courses. We do have a handful of real quick kind of brief nuggets of workers' comp information that you can find on our website. We do have on our website pages that are broken down by each system participant. So for injured employees, for employers, healthcare providers, insurance carriers, that have very specific information for those individuals. So I would recommend you poke around there, see if that helps answer any questions that you have. We're also open to doing on-site presentations and ad hoc presentations as needed. So if that's something that you might be interested in, then please reach out to our customer service line, and we can try and help get something scheduled for you or your organization.
Right. The customer service line is a good starting point for a lot of stuff, and they'll get you to the right person from there. Here's the next question. Does Texas have an electronic benefits calculator available?
Oh, so that one, we don't have an electronic benefit calculator. When it comes to income benefits, those are a little more, based off of what's reported on that wage statement to calculate the average weekly wage. And then if you're talking about medical benefits, then it really comes down to the fee guidelines and the fee schedule. So there's unfortunately not a kind of plug and play calculator that we have at this time.
Okay. All right. Sounds good. Next question. Touching on the days that must occur before temporary income benefits can begin, you said those can be cumulative. What are the circumstances when the clock stops, if at all?
Sure. So in order to receive temporary income benefits, there has to be at least 7 days of missed work. And there's not really a time frame on that. It could be 1 week, this month, or I'm sorry, 1 day this month, maybe 2 days next month. Then maybe there's 3 months where there are no missed days because of the injury. But there's really not a stopped time frame on when those cumulative days can occur for the work-related injury. Most typically, 104 weeks after the date of injury is when most income benefits just statutorily are no longer owed to an injured employee. So, if you have any questions specifically about a claim where maybe there's a day here or a day there, I'd highly recommend that you contact our customer service line and we can help talk to you about that.
All right, sounds good, Kel. Here's a question about safety services. Does TDI do OSHA stuff?
So OSHA is a specific federal agency. We do work quite closely with OSHA, but there are, I believe, construction courses that our agency does offer when it comes to requirements with OSHA.
Okay, sounds good. Circling back to our first question, if someone declines workers' compensation and potentially has a compensable claim, what are we supposed to do? Do you investigate and determine compensability?
Sure. So as a carrier, right, if an injured employee opts not to be part of the policy, then it might be appropriate for you as a carrier to file a notice of denial. If that claim is reported to you as the carrier, then just to sort of cover your bases, it might be necessary to issue a plain language notice denying the claim in that situation.
Okay, Kelly, we're just about out of time, so I'm going to do one more. This one,
Sure.
along the same lines. Does an employee have the right to change their status from refusing workers' compensation before employment in the future?
Sure. So once they have opted, not to be part of that workers' compensation policy within those first working days, I'm not sure that they can go back and change their ability to opt out of the policy. That's a good one that I will definitely look into and follow back up with the group on that.
Okay, sounds good. Unfortunately, we are out of time now. We're going to have to wrap it up. If we didn't get to your question, and I know there's still a few on the list that I was looking at, or you think of something else that we haven't addressed that you think we can, please email us again at dwcinsuredqa@tdi.texas.gov, and we'll try to get you an answer. And that's it for today. Thanks for joining us. Have a great rest of your day, and we'll see you at the next TDI webinar.